5 seconds to go. Start. Therefore, it cannot be said that the abusive language which had been used by the appellant on 25th July 1998 drove the deceased to commit suicide. Suicide by the deceased on 27th July 1998 is not proximate to the abusive language uttered by the appellant on 25th July 1998. The fact that the deceased committed suicide on 27th July 1998 would itself clearly point out that it is not the direct result of the quarrel taken place on 25th July 1998 when it is alleged that the appellant had used the abusive language and also told the deceased to go and die. This fact had escaped notice of the courts below. A plain reading of the suicide note would clearly show that the deceased was in great stress and depressed. One plausible reason could be that the deceased was without any work or avocation and at the same time indulged in drinking, as revealed from the statement of the wife Shrimati Neelam Sengar. He was a frustrated man. Reading of the suicide note will clearly suggest that such a note is not the handiwork of a man with a sound mind and sense. Srimati Neelam Sengar, wife of the deceased, made a statement under Section 161 CRPC before the investigation officer. She stated that the deceased always indulged in drinking wine and was not doing any work. She also stated that on 26 July 1998, her husband came to them in an inebriated condition and was abusing her and other members of the family. The prosecution's story, if believed, shows that the quarrel between the deceased and the appellant had taken place on 25th July 1998, and if the deceased came back to the house again on 26th July 1998, it cannot be said that the suicide by the deceased was the direct result of the quarrel that had taken place on 25th July 1998. Viewed from the aforesaid circumstances independently, we are clearly of the view that the ingredients of abatement are totally absent in the instant case for an offence under Section 306 IPC. It is in the statement of the wife that the deceased always remained in a drunken condition. It is common knowledge that excessive drinking leads one to debauchery. It clearly appeared, therefore, that the deceased was a victim of his own conduct, unconnected with the quarrel that had ensued on 25th July 1998, where the appellant is stated to have used abusive language. Taking the totality of materials on record and facts and circumstances of the case into consideration, it will lead to the irresistible conclusion that it is the deceased and he alone and none else is responsible for his death. It could thus be seen that this court held that both the courts below had erroneously accepted the prosecution's story that the suicide by the deceased was the direct result of the quarrel that had taken place on 25th July 1998, wherein it was alleged that the appellant therein had used abusive language and had reportedly told the deceased to go and die. It was held that even if one accepts the prosecution's story that the appellant did tell the deceased to go and die, that itself did not constitute the ingredient of instigation. This court held that it was common knowledge that the words uttered in a quarrel or on the spur of the moment could not be taken to be uttered with mens rea. It has been held further that the alleged abusive words were said to have been told to the deceased on 25th July 1998 during a quarrel, and the deceased was found hanging on 27th July 1998. This court held that if the deceased had taken the abusive language seriously, he had enough time in between to think over and reflect, and therefore it could not be said that the abusive language which had been used by the appellant on 25th July 1998 drove the deceased to commit suicide on 27th July 1998. It has been held that the suicide by the deceased was not proximate to the abusive language used 2 days prior. Additionally, this court held that a plain reading of the suicide note made it clear that the deceased was in great stress and depressed, and the suicide note also clearly suggested that it was not the handiwork of a man with a sound mind and sense. As such, this court held that there was no material to establish that the accused had abetted the suicide committed by the deceased. Relying on the decision in the case of Sanju alias Sanjay Singh Singer Supra, this court in the case of Gurjeet Singh Supra set aside the conviction under section 306 of the IPC, as it was clear from the evidence on record that there was a time gap of about 2 months between the last visit of the deceased to her parents with regard to the illegal demand for money by the accused appellant and the date of commission of suicide by the deceased. As such, this court held that there was nothing on record to show that there was a proximate nexus between the commission of suicide and the illegal demand made by the accused appellant. This court observed as follows. It could further be seen from the evidence on record that the time gap between the last visit of the deceased to her parents with regard to the illegal demand and the date of commission of suicide is about 2 months. As such, there is nothing on record to show that there was a proximate nexus between the commission of suicide and the illegal demand made by the appellant. In Sanju versus State of MP, Sanju versus State of MP 2002 5 SCC 371, this court found that there was time gap of 48 hours between the accused telling the deceased to go and die and the deceased committing suicide. As such, this court held that there was no material to establish that the accused had abetted the suicide committed by the deceased. Thus, this court has consistently taken the view that instigation or incitement on the part of the accused person is the gravamen of the offense of abetment to suicide. However, it has been clarified on many occasions that in order to link the act of instigation to the act of suicide, the two concurrences must be in close proximity to each other so as to form a nexus or a chain, with the act of suicide by the deceased being a direct result of the act of instigation by the accused person. This court, in the case of Mohit Singhal Supra, reiterated that the act of instigation must be of such intensity and in such close proximity that it intends to push the deceased to such a position under which the person has no choice but to commit suicide. Stop.